Michael Irvin has just scored a big win in his $100 million defamation lawsuit against Marriott Hotels and the Jane Doe defendant employee who accused him of misconduct during the Super Bowl week and got him canceled from TV appearances. In this video, we're going to look at the Marriott's response in opposition to Irvin's motion for expedited discovery of the surveillance tape, as well as the court's order on that. Before we get into the video, a quick disclaimer: this video is not legal advice. Now, with that out of the way, let's get into today's video. So here we have Marriott's response filed on February 28th. One thing that you'll quickly notice is how contentious and just aggressive it is in its tone. Typically, when a defendant doesn't have the facts or the law on their side, the only thing they can do is what we call saber-rattling, which is making a whole lot of noise, leveling all kinds of baseless accusations, attacking the other side's attorney. These are things that you'll see a defendant who knows that it's in the wrong do. Marriott's opening salvo in its response states that plaintiff's motion for expedited discovery lacks any legitimate basis and is an affront to the integrity of the judicial system itself. Having failed in his attempt to home cook Marriott with an ex parte discovery motion in state court, which lacked jurisdiction over Marriott, plaintiff has filed another baseless motion in this court. Plaintiff seeks expedited discovery in a case that presents no urgency whatsoever for the admitted and illegitimate purpose of trying this case in the media, with complete disregard for the safety and privacy of the employee who reported the incident and other potential witnesses. Plaintiff hopes to obtain the footage so that he can fashion a narrative, feed his propaganda machine, and improperly invite potential jurors to prejudge this matter in his favor. Likewise, it is apparent that plaintiff seeks to identify the employee who reported the incident and other witnesses, opening them to surveillance and scrutiny by plaintiffs, private investigators, media, members of the public without safeguards attendant to the discovery process. The court should not allow plaintiff to subvert the judicial process, bypass procedural safeguards, and achieve an unfair advantage with such unilateral discovery. To that, I would say the only unfair advantage here is really Marriott, which has all of the evidence in its possession and will not turn it over to Irvin. Marriott argues that Irvin does not identify any irreparable harm that will result from following normal discovery protocols. The only urgency he portends is litigating in the court of public opinion, purportedly in an effort to convince the NFL to let him cover the NFL Combine. This assertion is smoke without fire. According to plaintiff, the video footage he seeks was already voluntarily turned over to the NFL. So Irvin's assertion that letting the NFL see it and again judge for themselves again will somehow alter its treatment of him is completely undermined by his own motion. And then the response goes on to state that this leaves Irvin's desire to litigate his claims in the court of public opinion as the only potential basis for expedited discovery. Now, the fact that Marriott is so concerned about the court of public opinion and trial by media in this case indicates to me that the surveillance footage is not going to vindicate Marriott. If anything, it's going to show a completely cordial interaction between Irvin and his accuser. And that is why Marriott is throwing everything it can at Irvin to try to delay or block Irvin from getting that footage. Marriott argues that despite plaintiff's implications to the contrary, there was nothing improper about Marriott's removal to federal court, which fully complied with the applicable federal law and this court's local rules. Indeed, one of the fundamental policy considerations underlying removal is avoiding the type of home cooking that plaintiff has tried to perpetrate here. And then moving on to this section down here on page 6, Marriott states that in the wake of the filing of plaintiff's lawsuit, the hotel and its employees have already begun receiving threatening phone calls from plaintiff's supporters and multiple inquiries from plaintiff's agents seeking to uncover the identity of the employee who purportedly accused plaintiff of misconduct. Then on the next page, page 7, it states, because Marriott has credibly challenged the court's jurisdiction over this matter and whether this court is the proper venue for this action, it would not be prudent for this court to order expedited discovery until Marriott's jurisdictional objections are resolved. It is evident from the procedural history of this case that plaintiff brought this case in Texas not because he believes that jurisdiction or venue is proper here, but because he hopes to achieve an unfair home field advantage. Then Marriott goes on to argue that Irvin's argument proceeds from the assumption that the evidence he believes is in Marriott's possession and particularly any video evidence of the alleged interaction between plaintiff and a hotel employee, would be exculpatory. Plaintiff suggests that the NFL would permit him to recommence coverage of NFL events if he could blast the video in public media and show it to NFL officials. Plaintiff's motion makes the fatally inconsistent allegation, however, that the evidence he now seeks is, quote, the same evidence that defendant voluntarily turned over to the NFL, end quote. In other words, by plaintiff's own admission, the NFL has already seen the video and judged for itself. So showing them the video again would be futile and unnecessary. Moreover, the only specific upcoming event plaintiff claims he may be permitted to cover if the NFL rewatches the video is the NFL Combine, which is already underway. Even if there remained some urgency, which plaintiff has failed to identify, plaintiff wants the video for the plainly illegitimate purpose of litigating his claims via the media. Then Marriott goes on to argue that plaintiff's counsel, that would be Irvin's attorney, has already made prejudicial extrajudicial statements, that means statements outside of court, baselessly implying that Marriott's proper removal to federal court and resistance to participating in discovery, that means not turning over the footage, that is not authorized by the federal rules absent court order is somehow sinister or an attempt to hide relevant evidence. Additionally, in the wake of plaintiff's extrajudicial statements, media reports have suggested that the court should and will look more favorably on Irvin as an individual than Marriott as a corporation. Then Marriott goes on to argue that the court should not permit plaintiff to obtain the expedited discovery in furtherance of continuing his improper prejudicial PR campaign. Plaintiff's conduct is not only harmful to Marriott, the hotel at issue in this litigation, and the hotel employees who have been subjected to threats and harassment, but it also undermines and demeans the integrity of the judicial system and taints the potential jury pool. What is ironic about this statement is that this is a situation where Marriott has inflicted major harm to Irvin, and now Marriott is claiming to be the victim here. It's bizarre. Moving on, it says the media frenzy plaintiff and his counsel have created has encouraged members of the public to threaten hotel employees. Additionally, the threats and security risks that would attend any public revelation of the identity of the employee who allegedly reported plaintiff's misconduct would unquestionably harm that employee who is a third party to this litigation. These threats underscore the importance of Marriott's decision to maintain the anonymity of the employee who reported the misconduct. The primary piece of evidence plaintiff seeks, the video, cannot be redacted. If plaintiff obtains and publicly disseminates the video as he intends, the media and the private citizens undoubtedly will seek to identify the employee using that image. Plaintiff cannot ethically crowdsource discovery in this manner using third parties who are not constrained by the rules of ethics or otherwise appropriately licensed. Second, threats received to date have been directed at the hotel, and plaintiff's team of private investigators and agents have entered the hotel seeking extrajudicial discovery regarding the substance of plaintiff's claims. Accordingly, redacting the identity of the single employee in question will do nothing to guard against plaintiff's abuses. And so I'm not sure here why Marriott is saying that it cannot blur out the identity of the female staff member in the video or even put a black box around her so that you can't see her at all. I'm not sure why Marriott is saying it can't redact her identity from the video, and Marriott doesn't bother to explain that here. So I'm not sure that's a legitimate argument here. Now that you've seen Marriott's response to the motion for expedited discovery that Irvin filed, let's take a look at the court's order. Here we have the judge's order on March 1st, 2023, where it is granting Michael Irvin's motion for expedited discovery. And let's take a look at what the judge is saying about the surveillance footage and when Marriott must produce it. Moving on to the analysis section of the court's order, it states that Irvin's stated good cause for this request is his desire to remedy ongoing reputational damage stemming from the alleged incident and to seek reinstatement with the NFL. In essence, plaintiff seeks expedited discovery to better understand the, quote, who, what, when, or where of the allegations levied against him, and begin the process of addressing those allegations. In response, Marriott argues that expedited discovery is premature and unwarranted given its pending motion to dismiss and transfer this case. Defendant also argues that plaintiff seeks expedited discovery for the improper purpose of litigating the case via media and exposing his alleged accuser to harassment and unwanted scrutiny. Considering the record before it and surrounding circumstances, the court finds that plaintiff has carried his burden of establishing good cause for the expedited discovery. To be sure, plaintiff does not point to the type of urgent justification that usually warrants expedited discovery. For example, a pending motion for preliminary injunction. But, the judge says, he does allege immediate and ongoing harms, both reputational and economic, that could plausibly be impacted by expedited discovery here. Moreover, the discovery that plaintiff seeks is narrow and unlikely to be particularly burdensome on Marriott. Indeed, plaintiff's request is limited to surveillance footage and written reports, all of which likely exist in readily accessible format. Now, then the court goes on to say that it does, however, find that Marriott's concern for the privacy of the hotel employee, the Jane Doe defendant, who allegedly reported plaintiff's misconduct, is well-founded. I would totally 100% agree with that. Thus, the court will allow Marriott to redact the employee's name from any written reports and take reasonable measures to protect the employee's identity as necessary at this early stage of the case. Then on the next page, the court goes on to state that the local rules make clear that a pending motion to dismiss or transfer venue does not give a party license to refuse to participate in discovery. Then at the bottom of the page, the court points out that nor is there any risk that the expedited discovery will cause wasted effort here because the footage and documents sought by plaintiff will undoubtedly be discoverable and highly relevant, irrespective of whether this case is litigated in this court, in the District Court of Arizona, or elsewhere. And that is a very good point right there. In the footnote, it says, although Marriott characterizes the discovery sought by plaintiff as merits-based discovery, the facts pertaining to Marriott's investigation of the alleged incident may be relevant to the resolution of Marriott's jurisdiction and venue objections. So I think that's an interesting point, and it's kind of telegraphing that the court may try to keep the case in its own court. We'll have to see what evidence Marriott turns over to Irvin. Then moving on to the final page of the court's order, it states that it is further ordered that defendant must produce the items and documents sought in plaintiff's request for production number 1 no later than March 7th, 2023 at 5 p.m. So there you have it, folks. By March 7th, 2023 at 5 p.m., Marriott must turn over the surveillance footage as well as any witness statements and investigative reports that it has in its possession, custody, or control to Irvin. So make sure to hit that subscribe button below and turn the bell notification icon on so you don't miss my next update video. Once that comes out, you're definitely going to want to check it out. And of course, as always, thank you for watching.